Hello and welcome back to the channel. And today we're going to be talking about civics, obviously. But today we're going to be talking about antitrust laws and specifically Taylor Swift, which is a fan favorite topic of mine, in case you didn't know that about me. Taylor Swift recently launched or announced her latest tour, and it turns out getting tickets to that was pretty difficult. And it's brought up a lot of antitrust discussions. And so I figured we should probably talk about what that means and what those laws are. So we're going to talk a little bit about antitrust laws, and we're, of course, going to relate it to Taylor Swift, because why wouldn't we? So what happened? Recently, right, Taylor Swift announced her Eras tour, and tickets were on sale through Ticketmaster. Ticketmaster operates as a near monopoly, and they control over 70% of ticket sales and venue booking in the United States. So basically, they have control of the market. The sales were marred with long wait times, system crashes, and lots of problems, and tickets ended up becoming incredibly expensive due to Ticketmaster. So let's talk about what a monopoly is exactly. It's when one company is in control of a market, right? There's limited competition because only one company dominates it. Historically, monopolies have been dangerous for the economy and consumers because when corporations have full market control, they can set prices at whatever they want and charge excessive fees to drive up their profits since no one can compete with their market power. You can't get tickets anywhere else anymore. You have to get them from Ticketmaster. So they can charge whatever they feel like. A previous monopoly you might know of is AT&T. They used to be the only phone company. Now, right, there are others, and that's because of an antitrust lawsuit, which we'll talk about in just a second. So what exactly is an antitrust law, right? That's the other big part of this video. Antitrust laws began to pop up in the 1880s when Congress began to pass antitrust legislation for the first time to break up monopolies in the steel and oil industry. Antitrust laws allow the federal government to stop mergers and purchases that would create monopolies or allow corporations to have too much market power. So basically, at this time, Congress realized it's not good when one company has that much power over a single market. It can cause problems, so we're going to make it so they can't do that anymore. Antitrust suits are argued in federal courts and often have the United States as the plaintiff, but not exclusively. Sometimes it's a state, sometimes it's an individual. But the U.S. can be the plaintiff in these cases. The first of these laws that really made an impact is the Sherman Act. It's the first antitrust law in the U.S. It was named after its principal author, Senator John Sherman. Its goal was to prevent the artificial raising of prices by restricting trade or supply, basically what a monopoly can do. The Sherman Antitrust Act prohibits anti-competitive agreements and unilateral conduct that monopolizes or attempts to monopolize a relevant market. The Act also allows the Justice Department to bring suit against violating parties and injured actors to sue for up to triple the cost of the violation. So people who are hurt by these actions can get up to 3 times the amount that they lost because of this. Federal courts have also developed a body of law fleshing out the Sherman Act since its passage. So there's lots of different things that go along with this. This is kind of a basic understanding of what that law does. In 1914, the Clayton Antitrust Act was passed to beef up this antitrust law, this body of law in the U.S., and the act seeked to prevent anti-competitive practices before they even began. The Clayton Act establishes that there are certain practices that are prohibited. They established a 3-level enforcement scheme to make sure that these practices were not done, and they created exceptions and remedial measures for the law. The Clayton Act was partially in response to the wave of mergers that followed the passage of the Sherman Act. It also worked to stop using antitrust legislation from being used against labor unions. So when the Sherman Act was originally passed, instead of using it to break up big corporations like United Steel or U.S. Oil, it was being used to stop labor unions, which was not the purpose of the law. So the Clayton Act tried to fix that a little bit. So let's talk a little bit about the history of these antitrust laws and how they worked. In 1920, an antitrust legislation was used to try and break up U.S. Steel. It basically had control of the entire steel market. The court found the U.S. Steel did not have enough market power to overcome all of its competitors and was allowed to stay together. It was also cleared of price fixing since it did not have the monopolistic power it was accused of. So that in that case, it didn't actually work. Microsoft in 2001 was accused of forming a monopoly in the PC market by limiting computer makers and forcing computers to have Internet Explorer installed on computers. The case made it to the Federal Court of Appeals and held that Microsoft violated the Sherman Antitrust Act. Microsoft was forced to separate Internet Explorer from its Windows operating software, seen as a slap on the wrist. So they were punished, but not really. So antitrust laws have not always worked out the best, but there are cases where they have. There are a lot of recent mergers, basically tech companies, that have drawn the ire, right, of people who are calling for antitrust suits to be leveled against them. Companies like Google, Amazon, and Apple have prolific market power in their respective fields, and so there have been calls to potentially have an antitrust suit put against these people. So let's get back to Taylor Swift. The inability to get Taylor Swift tickets is a perfect example of a company merger that could never have taken place. Ticketmaster has become so powerful that they can implement high prices and terrible business practices with impunity. In recent years, antitrust suits have been less successful than during their heyday in the late 1800s and early 1900s, but maybe it's time they start being more successful again. This kind of monopolizing the market has allowed Ticketmaster to get away with things that would normally not be acceptable if they had more competition, right? If there was other companies that could rival Ticketmaster's market power, then they wouldn't be able to get away with this stuff because then people would just buy their tickets elsewhere. But because Ticketmaster is the only company, right, the only one that has this available, they can kind of get away with it. Thanks so much for watching and learning about antitrust legislation and what it can do. I hope you found it interesting, and we'll be back with more civics later. I hope you enjoyed, and we'll see you later.